Good evening, everybody. I'm James Spadola, City Council at Large. Thank you all for coming out. Many thanks to Attorney General Kathy Jennings' office and Chris Curtin specifically for providing this opportunity for some good old-fashioned training for civic associations. It's the second year in a row, so we're excited to offer this to you. And this is all, I think, to me, you see how it was explained, but it's really about how can civic associations be the most efficient and govern their civic association in accordance with the law, but also knowing the resources that the AG's offices have for civic associations and for members of those communities that might have issues with their governing bodies of the HOA and or civic associations. So with that, I think I'm going to take a seat in the crowd, but happy to kick it off to you, and good to see you again.
Thank you. Nice to be here. My name is Chris Curtin. I'm a Deputy Attorney General. I've been the Common Interest Community Ombudsperson for the last 10 years. This is a new office. Even though it's 10 years old, I'm still reaching out to as many communities as there are. We don't even know how many common interest communities there are in Delaware, and our office is centered around common interest communities. Some civic associations have some things in common with common interest communities, but they're different in some respects, and my office is aimed at common interest communities like condominiums, cooperatives, and homeowners associations that have deed restrictions and are freestanding residential communities for the most part. But we try to help civic associations in any way we can, especially since there's a lot of overlap between the law and creation and the issues that common interest communities and civic associations both face. My usual function is to speak to those in common interest communities, and tonight I know that there are probably mostly civic association members here. Are there any people here who live in condominium? A cooperative? How about a homeowners association with a homeowners association governing board? So tonight the audience looks like it's mostly common interest communities. Some of the things I'm going to be talking about are aimed at common interest communities, but they don't exclude civic associations. So we'll go from there. You've caught me on a night when I'm choking on tree pollen, so I'll try to keep my voice up, but I apologize that I don't have my usual voice, and I wore it out last week at an advisory council meeting for Common Interest Community Advisory Council anyway. I think I will start by discussing the Office of the Common Interest Community Ombudsperson, so you'll get an idea of what I do and what I'm authorized to do under statute. The Common Interest Community Ombudsperson Act was created in 2014 as a new office at that point. It's only one of 6 common interest community ombuds offices in the nation, and it's the only ombudsperson that's in an attorney general's office. And as a result, I'm the only ombudsman that has his own subpoena power, and I'm the only deputy attorney general with a separate subpoena power in addition to the general subpoena power in the attorney general's office. Our statutorily defined purpose is to assist those in common interest communities, and I extend that to civic associations, to understand their rights and responsibilities and the processes available to them according to the law, regulations, and documents governing their respective common interest community. And we're going to unpack that purpose. As ombudsman and as a deputy attorney general, I can't provide legal interpretation nor legal advice to either common interest communities or to to civic associations. But many of the laws, although not directly applicable to civic associations, can be stretched to their to civic associations. I guess the first question is, what is the definition, or what are the characteristics of a common interest community, and how are they different from civic associations? And condominiums, as I started the conversation tonight by asking how many lived in a condominium, how many live in a cooperative, and how many live in a residential subdivision, commonly referred to as a homeowners association. And those are common interest communities that are the subject of the legislation that created my office. The common factors for a common interest community are that the membership is mandatory and automatic. In civic associations, the membership is voluntary and it's not automatic. In common interest communities, a developer records at the recorder of deeds, deed restrictions, and a declaration, a recorded land document called a declaration that sets out all the deed restrictions for the community. And among them are that the community is being created as a common interest community, which is distinguishable from a civic association in that regard, and that membership is mandatory in that common interest community. But similar to a common interest community, to a civic association, the documents that are creating the community do bind all purchasers to be governed by an association. Both civic associations and common interest communities are community associations, and but they are different. The documentation that binds a common interest community will be much more detailed in terms of deed restrictions than that for the civic association. Civic associations may have in their individual deeds some enforceable restrictions. One common one is that each person in the community of a civic association may be required to participate in road maintenance by paying a fair share of road maintenance or snow plowing. In common interest communities, the extensive deed restrictions are almost of famous repute now in that they can extend to such things as having to get permission from a homeowners association board in order to make an addition onto the home, have a roof of a certain color, and devising a scheme of who's responsible for what common areas in the community. For example, I see a lot of litigation every year especially about condominiums, about who is responsible for the windows, because the declaration and the bylaws of a condominium community will say in one case that it's the windows are the responsibility of the owner, and in another case that it's the responsibility of the community association, the condominium association. So the documents of creation of the community go a lot to define what can and can't be done and what the differences are between a civic association and a common interest community. The third distinguishing feature of common interest communities between common interest communities and civic associations is that common interest communities in their recorded land documents state that there is a mandatory lien-based assessment that each person will be required to pay each year toward the maintenance and the operation of the community association. In civic associations, membership in the community association is voluntary, and so are the dues. But otherwise they govern in very similar respects. Yes, questions at any time would be welcome.
My question is, you said something about residential subdivision. Now, where I live, it's a residential subdivision, but we have no HOA.
That would be a defining element of a civic association as opposed to a common interest community.
Okay, so
Not all, if civic associations and common interest communities are all, community associations, but the types of responsibilities and rights and authority differ tremendously.
okay. So even though it's a subdivision, it's not mandatory that they have a HOA, which puts them in the category of a civic association.
That's right.
Okay,
The declaration that's recorded in the land department, the land records of a common interest community will say that the developer is not only creating the declarations and the deed restrictions, but is also creating a corporate, usually a corporate entity that will be the community association for the community, and it will have a board made up of the members of the community, and it states all sorts of regulations about not only the rights and responsibilities of the people living in a common interest community, but also what the obligations of the board members are as well. And that's different than a voluntary civic association, community association.
So this subdivision, could it start a civic association for that subdivision?
It is possible to create it, but it's very difficult. Generally, the deed restrictions for a common interest community are recorded before the first home is sold, so that everybody is bound by the regulations in the common interest community without exception.
Now, that's the HOA, correct? Is that the
Yes,
same thing with the civic association?
A homeowners association is a deed restricted community is commonly referred to as an HOA, but they're in the law they're called planned unit developments, and that's the difference. There's a lot of overlap and confusion when it's just the use of the term HOA or homeowners association, because homeowners associations technically are civic associations as well, but the law defines planned unit developments as what people commonly refer to as a homeowners association these days.
Okay. So how would you go about forming a civic? Because it's too late now. We can't do the HOA because it was just a point. So what is the process, or how do you go about creating a civic association for that subdivision?
A civic association can be created by creating some kind of usually it's a corporation that's formed, and volunteers create the corporation, and then they solicit people in the community to join the voluntary civic association, pay dues, and discuss issues that are of importance to the community association. There's a great website that I was going to talk about more later on that can help get you focused on community or on civic associations rather than common interest communities, and that is the Council of Civic Organizations of Brandywine 100. They have an extensive website that has even model bylaws, discussion about how to form a civic association, and tons of resources. If you go to ccobh.org on your website, you'll find the Council of Civic Organizations of Brandywine 100 website. I think they have maybe 140 member communities, some of which are common interest communities, but mostly they are civic associations. But they help each other by having meetings of their own and instruction of their own. One of their attorneys is Bob Valahura, who helped create the DCIOA, the Delaware Uniform Common Interest Ownership Act, which governs common interest communities. But now he's a president or president-elect of the Council of Civic Associations for Brandywine 100. He's an experienced land attorney, and he does speaking on teaching for civic associations as opposed to common interest communities. And I would encourage you to go there. You can spend days reading about common interest communities, more than I can provide you tonight. But if you take away nothing else, go to ccobh.org and read about membership in them. One of the ways for gating information about a civic association's plans and duties is to go door to door. And in common interest communities, sometimes when there's a lot of disagreement or if there is a lack of attendance at meetings, people are encouraged under the corporation law to go door to door to get the votes that they need or the people that in attendance for a quorum to run the community association the way it should be run. Both of these can be corporations. Neither has to be a corporation, but if they are a corporation, the Delaware General Corporation Law will apply to either form. But a community association can be less than a corporation. Another difference between civic associations and common interest communities is that by purchasing land in a common interest community, with like an HOA community or a condominium or a cooperative, you have already agreed to abide by all of the deed restrictions that are recorded in the land documents for that kind of community. And that's another difference that's made clear by the fact that there are recorded land documents, and because they also started at the moment that the community was declared to be a common interest community. So the voluntariness of membership is one critical difference between common interest communities and civic associations. However, since if it's formed as a corporation, you still will be guided not only by what's in your deeds, but also by what's in the general corporation law. Delaware corporation law requires all corporations in Delaware to have bylaws, and they have to be followed. One difference is that in common interest communities, the bylaws since 2009 must be recorded in the Recorder of Deeds office, but it's not a bad idea to have any bylaws recorded in the Recorder of Deeds office so that they are available as public records, public documents for anybody who's in either type of community association. In a common interest community, in addition to the, first of all, they are not required to be corporations, but if they are still required to abide by the Delaware General Corporation Law, which imposes a lot of additional requirements above and beyond what the general law of common interest communities is. Since 2009, Delaware adopted a uniform statute created by the Commissioners on Uniform State Laws called the Uniform Common Interest Community Act. The Delaware version is very, very similar to the Uniform Act, and it's called the Delaware Uniform Common Interest Ownership Act, or you'll commonly hear it referred to as the Kiowa. At least that's the preferred pronunciation among realtors and lawyers practicing in that area. And I like it because it's easier to remember. If you like basketball, Duke, Iowa, which is why I prefer that pronunciation. The next question, I guess, that I commonly get is, what the heck is an ombudsman? But usually it's a government official who receives complaints, reports on complaints, and deals with problems in a fair manner. And that overview is one of the legs that my office stands on. We receive complaints. Most usually it's a homeowner with a complaint about how the board is operating or failing to operate under the bylaws of the community association, but it can be complaints among neighbors, even in civic associations. I think we don't turn away complainants under our procedure for filing a complaint that I'll get to in a little bit, just because they're in a civic association. But we receive complaints, many of them every month, and we have a process that the statute required us to create, and it limits us on what we can do under as Ombudsman's office. But we do report on complaints as well. The statute also requires me to report to the General Assembly, the Supreme Court, and the Attorney General by an annual report each year. And a large portion of it is what complaints are you hearing about in common interest communities. And my typical annual report has pages of the complaints that I'm hearing about, and in one-liners. And I can go into some of what those complaints are a little later, but many of them affect both common interest communities and civic associations. And we do try to deal with problems fairly. We have different processes, but they start with an internal dispute resolution complaint form, where the person with a complaint is required to go to their governing documents, which, whether it's a declaration, a deed restriction, a certificate of incorporation about the operation of the community association, however it is, or any bylaws of the community association, since general corporation law requires all corporations to have bylaws. And we ask that a complainant, regardless of what kind of a community they're in, they cite and quote the documentation that they believe justifies their complaint, and that they submit that in writing on a form that we put together as part of our obligations under the Act, and deliver it to the governing body or to the neighbor that's in violation, and see if they can't talk it out without involving government or litigation through the courts. And we try to encourage people to do what's required under their governing documents, however they're formulated. We try to get people to agree to mediation or arbitration or binding arbitration. And we can provide mediation, arbitration, or binding arbitration, but our statute requires us to charge fees for it. So I've arranged with the Delaware Court of Common Pleas that they will accept for free mediation under their community mediation program any referrals that we make, and we refer both common interest communities and civic association disputes to Court of Common Pleas community mediation. We don't charge a fee for filing it as we do for complaints under the, come to us as common interest community complaints. So it can be absolutely free, and we try to encourage the best we can to get people to go. My office does not permit us to provide legal advice to one side or the other, but we can provide general information, usually in the form of practical knowledge or a reference to a statute that may or may not, but looks like it could apply, to provide guidance about how to resolve a given complaint. There are also occasionally problems under the that we receive. Sometimes a board will have an issue with a landowner or a homeowner in the community, and they're allowed to use our process as well. And we've found that almost no common interest communities have declarations that allowed a homeowner to file a complaint against the community association board. So our statute required creating that process, but it is one that any community can use, and in either direction, either a homeowner against a board, a homeowner against another homeowner, or a homeowner's being asked by a board to explain a complaint. The general purpose of the Office of the Ombudsperson, as I stated earlier, is to assist in understanding rights and responsibilities and the processes available. And our processes include the internal dispute resolution process that I described and will describe a little more later. We are not allowed to provide legal representation to any party in a homeowners association or a civic association. We can't provide legal advice. We can't provide legal interpretation. If only the general non-binding information is the limit of what we're authorized. For anything else, legal representation is required, and that requires consulting a private lawyer. If the facts and the law in a question, I can't do more than provide some general guidance pointing towards law. I can't provide legal advice or interpretation. That has to be provided by a lawyer in private practice.
We got a question.
Yes, ma'am.
Yes, I have a question. We have had a civic association for many years, but there's never been any recorded bylaws. And
I'm sorry, there's never been any.
Recorded bylaws.
If there are bylaws are not required by a civic association to be recorded. They are required by the DCIAWA for common interest communities. Civic associations are not prohibited from recording bylaws, and I recommend it as a best practice because so many times before even common interest communities were required to record bylaws, there were many common interest communities that lost their bylaws, and the board presidents would make up bylaws. But under the general corporation law, the board president, the board, they can't just make up bylaws. They can recommend bylaws, but the Delaware General Corporation Law reserves to members of a corporation the right to the final say on whether to amend or create bylaws. So if they have not been recorded, it would be a means of getting it the same document available to everybody in the community and subject to the general corporation laws requirement that the bylaws only be modified by a majority of the members of the corporation, not by the board by itself or the president by themselves.
Well, but for a civic association, though, because I'm getting confused between what's required for a corporation, which I guess a civic association is not a corporation.
If the civic association is not a corporation, it's not covered by the general corporation law.
Right, but
And it's
what
not required to have bylaws.
are there any codes or laws that oversee a community civic association?
There is a statute called the Unincorporated Nonprofit Corporation Law, which allows, it doesn't provide much protection, and it's not very well known, but it is a law that allows unincorporated nonprofit corporations to record things with the Recorder of Deeds office. And I don't have the citation with me, but I'd be happy. It's a Title VI statute, and I'd be happy to provide a citation of it to you if you'll leave me a note. In fact, I'll provide a citation through Councilman Spadora's office.
Okay.
Any other questions while we're here? Well, what the Common Interest Community Ombudspersons Act does allow is, and requires, in fact, me in several pages of duties to provide education about common interest communities. But I think that I have to include civic associations since, especially in Newcastle County, there seems to be more civic associations than common interest communities, although there are, and even in Wilmington, there's condominiums in Wilmington and throughout the county, and they are all common interest communities. But there are many communities that were created throughout Newcastle County before the enactment of the Kiowa and before common interest communities became a popular subject of government regulation and creation. So I think that things about knowing that the general corporation law is going to be applicable to your bylaws if you form a corporation, your governing body, among other things. And there's a few more things that I'll be hitting on that touch both common interest communities and civic associations. A second duty is providing mediation, arbitration, or referrals to the Court of Common Pleas or other agencies that might have authority over a particular problem. I find that in all types of communities, there's often need to refer a complaint to the insurance commissioner's office. That can be something in the in the civic association sphere, and to the Civic and Human Rights Commission. I'm astonished that we still find so many instances of bias, racial bias, or animus towards different racial groups, or handicap parking disputes, and federal statutes that under the Fair Housing Act that are not directly in the bailiwick of the Common Interest Community Ombudsperson, but are under the Human and Civil Rights Commission's authority. In fact, one of the things that we are also charged with is having an advisory council, and the chair of our advisory council is a former commissioner of the Civil and Human Rights Commission, and is still an active commissioner, but although not the chair of that commission, she's the chair of our advisory council. We occasionally have need for investigation, and this can affect civic associations as well. We have found in at least once in each county in the last few years that boards have been stealing money that was paid to the association, whether it's a civic association or a common interest community. And we have investigated by subpoenaing bank records, proving that it was theft. And in at least one instance in each county, we have obtained felony and conspiracy convictions for the board members who were stealing community association money. And I was speaking to a gentleman earlier about one that is actually fairly recent in one of the largest communities in Delaware with 1,339 homes. The prior two presidents were both caught stealing. The latest one committed suicide in 2023 when the county police were closing in on their investigation. She stole every dollar of 2 years worth of association maintenance payments to the corporation, totaling $160,000 that was apparently used for a business that she was running online. And the community is still struggling. We've provided them with new elections without charge, and the Newcastle County has created a new statute called Neighborhood Improvement Districts, and they are going to be the first new district in order to have a council person on the board, as well as mostly representatives of the community. But one of the core improvements that will be offered to that community are the county's billing program for common interest communities. They will send out the invoices, collect the funds, and disperse them to the community in periodic deliveries of money, but they're all subject to accounting and audit at the end of the year. And that the auditing is one part that was sorely missed in this. In fact, all the communities that there have been convictions, and that was not included in one of them because of the suicide of the thief. But the county's NID program, the Neighborhood Improvement District, will also provide a means for collection of delinquent assessments by adding any delinquency by the end of the year into the county tax bill of the delinquent person, so that they will face punishment from the county and if they are not current on their payments to the association, if that happens. That's likely to lead in other investigations as well. Another topic that is created by the Ombudsman's Act is we are required to provide on request and for a fee election monitoring and ballot counting for electing officers and directors of corporate common interest communities. And we've done that quite a few times. One was that community association, which was a common interest community where all that money was stolen. they couldn't afford our election services, so we provided them that for free and got them a clean board that has been operating properly since. And the last major duty that we have in the Ombudsman's office is we had to create an advisory council. It's called the Common Interest Community Advisory Council. It's 18 people that are appointed by various, mostly government officials, but a couple of, the governor appoints 3, 1 from each county. President pro tem of the Senate and the Speaker of the House each appoint 3. The Delaware Bar Association appoints 2 lawyers experienced in community association law, and the Community Associations Institute, a philanthropic nonprofit organization that supports common interest communities, appointed a single member from its staff to attend our common interest communities, and they had a large hand in the drafting of the Ombudsman's Act. The education process of our office requires information made principally through our website. If you haven't been to our website, it's probably not as broad-reaching as the CCOBH website, but there's a lot of valuable information available on our website that includes free information on running different types of corporations and community associations. We have a section on Newcastle County that has a county booklet on civic associations, as well as a different one for common interest communities and for maintenance corporations, which are a county required form of community association. And the maintenance corporations are also common interest communities besides being community associations. But on our website, we also provide information about running your common interest community. We have a simplified rules of order for running association meetings, which is aimed at small associations or small community type of associations, rather than some of the large-scale applications of Robert's rules like Congress and General Assembly and those things. The smaller communities can be far less formal, yeah. We provide educational programs and workshops. This meeting tonight and one like it last year has been aimed at common interest, not communities, but also civic associations. But we have made presentations on things like collecting delinquent assessments. We have done several on governance of community associations. If you're in a common interest community, a popular subject is transition from developer to owner control, which is a difficult time in the life of a community, and we've provided a number of those. We have annually provided, for the last 9 years, a board leadership development workshop. Although it's aimed at common interest communities, sometimes we have people come to from associations, civic associations to attend, although they don't find it as useful as those who are in common interest communities. We conduct meetings as part of our educational requirements at meetings like this to find out what are the concerns of people in the community. And I'm hoping that after my remarks, if there are some community concerns affecting your common interest communities or your civic associations, that we can talk about that. If you've never been to our website, I could show you around with these web links. I think they may be live on this program, but probably not. They there's a lot of valuable information on our websites, even for community or civic associations. Has anybody here, by any chance, been to our website to see, for example, the sample simplified rules of Robert's Order for small association meetings? That's something you could certainly do. You might find more and have more use on the CCOBH website. We do have on our website useful links, and there's the one for Newcastle County has probably more pertinent information, since it's got information about the maintenance organizations or civic associations under county law, as well as maintenance corporations and other kinds of community associations. But it also has links to the county's website, where I worked on a project with the Newcastle County Recorder of Deeds, Mike Kozakowski, to create a, his idea was to create a portal to services for community associations of all types on the county website. Among the things that you can do there that are of value to even civic associations is he created several things that I worked with him on. One is that if your community has racially discriminatory language in the governing documents, the recorded declarations or the deeds, you can file an application that's available on the Recorder of Deeds website, and for free, you can ask the county attorney's office to strike that discriminatory language out of the deeds, out of the official copy of the deeds, so that you don't have to be offended by it every time you read your deed or your governing documents. That's one that I assisted Mr. Kozakowski with. Another one was that he arranged to make state law such that if you have governing documents that you want to record for any kind of civic association, even bylaws, they can be recorded in Newcastle County for free. Usually it costs tens of dollars per page to record land documents in any county, but in Delaware's Newcastle County, it's the only county in Delaware where land documents can be recorded by owners in a community without charge. Also in Newcastle County, it is not only free to search your county's or your community's name under the recorded land documents, You can search for free. You can read the documents that are listed under your community association's name, like any deed restrictions or deeds, to see if there are maybe a common plan where every deed has certain information that can be enforced against any other, against the board or elsewhere. And you can download them and print them for free under Newcastle County code. But that, again, it's the only county in Delaware where land documents can be not only searched, but downloaded and printed for free. There are other links that might be of some value, but those are the top ones that I think are of interest to civic associations. I do want to spend a little bit of time talking about the dispute resolution processes in our agency. One of the most important and time-consuming jobs that we have in the Ombudsman's office is dealing with complaints. And as I explained earlier, we have created, following the statute, an internal dispute resolution complaint form. I know you can't read it on this thing, but it's available on our website to be downloaded. You can fill it out on our website. You can download it on our website to fill out by hand, and you can file it with our office or just follow the process. This is intended to lead to conversations that get complaints resolved rather than by litigation or even by board meetings. What it requires is that a person with a complaint, whether it's a board member or a homeowner in the community or an opposing homeowner, is to find the declaration, the bylaws, or the certificate of incorporation that you believe is being violated, and write out the exact language that you think is being violated, and to what you want done about it, and what your evidence is that it's being violated, or if it's not evidence, just what your feeling is that causes you to believe that it's being violated, and then to provide a copy to the person or entity that is responsible for the violation. Under common interest communities, it's most usually a homeowner who believes that the board is doing something that's not authorized or is in violation of the declarations or bylaws. And this invites the parties to discuss in a process called meet and confer, that where usually the board would appoint a member of the board instead of holding a hearing before the whole community association to discuss what the issue is and how they can reach agreement to resolve the dispute. It works for civic associations as well as common interest communities. And if there is an agreement reached through this process, it can be reduced to writing, it can be filed in court, and can be enforced the same way as a contract in court. Believe it or not, there are many, many more complaints in common interest communities than in civic associations, but far and away the most effective way that most complaints are handled is through using this internal complaint resolution form and meeting and conferring. That diverts, our experience is it diverts most complaints and most disputes away from further involvement of our office. However, if there is more that needs to be done. If they fail to reach agreement, they can request our office to provide either mediation, arbitration, or binding arbitration, or to refer them to for free mediation through the Court of Common Pleas Community Mediation Program. And I have to say that the second most popular method, rather than paying my office or others to mediate or arbitrate, most that are not resolved by internal dispute resolution are resolved with the assistance of free mediation through the Court of Common Pleas Community Mediation Program. If there is a dispute, I recommend that this form, the internal dispute complaint form, be filled out anyway. It can be used in more ways than just requesting internal dispute resolution. If people are pretty sure that their board is not going to hear any of it, they can at least sharpen their position by following the process that's required by this board, and don't even have to show it to anybody else. Just the process will sharpen the issues for others to hear it in a cohesive way with the allegation of what is being violated and what the evidence of that is, and what the person who's objecting wants to have done about it. Does not have to be required or escalated to my office. It can be used that way, or in the worst case scenario is that the parties cannot agree even to go to mediation for free, and one party then has the option to bring suit in the Court of Chancery. Chancery Court has unique special authority to resolve, enforce, and interpret homeowner association disputes, and they issue probably close to a dozen opinions a year about the subjects that find their way to the Court of Chancery each year. The advantage of going to the Court of Chancery is that it starts with mediation, but the mediation is not voluntary like it is through our office or through the Court of Common Pleas. Our mediation and arbitration are voluntary and consensual, and if the parties won't voluntarily submit, then that's the time that it makes sense to consider going to court if it's that kind of a problem. At court, the first thing that the Chancery Court does is appoint a Chancery magistrate to mediate, and it orders the parties to mediation rather than inviting them to mediation or cajoling them as my office can do. But by ordering them to mediation, that's an escalation that the court can make. If the parties do not resolve it at mediation in Court of Chancery mediation, then the court will order a non-jury Chancery Court trial, again to a magistrate rather than to a chancellor or vice chancellor. And it'll be a trial where evidence is heard and arguments made, and an opinion from the Court of Chancery will issue. And that will resolve it at considerable expense to the parties, but it'll resolve it, and this can help sharpen the issues before they get to that stage, and are another way that court involvement can be avoided.
Excuse me, no one's around, but I have a question.
Yes, ma'am.
How does that work when you may have a possible case of mental health in your community, and all authorities are saying,
Would you mind using the microphone? I'm sorry, I'm having,
okay, so sorry.
My ears have been clogged with pollen and sinuses, yeah.
How does this work when all authorities that you've communicated with feel as though a homeowner may have mental health and you cannot communicate with them, there's no relief in disputing or communication? How does this help us?
Well, my office tries to cajole people into cooperating. If it doesn't work, if volunteer consensual processes don't work, that's time to go to court. That's when the Chancery Court can exercise its exclusive jurisdiction to interpret and enforce governing documents of a community. And it's unfortunate that it has to go to that, but if people won't cooperate and won't consent to either consensual or voluntary dispute resolution, then it has to become mandatory, and it gets mandatory by calling on any of the courts, but the Court of Chancery has a unique jurisdiction to interpret and enforce homeowner association disputes.
Okay, so we should still use that form you're speaking of.
Yes, the form sharpens the issues, and that's why I recommend people start there, whether they're going to try to mediate formally, informally, by referral to Chancery Court, or even to go to Chancery Court. It sharpens the issues. So if you do speak to an attorney about going to court, you'll be focused on what you need to be focused on when you even speak to an attorney to represent you.
No, this is civic association. Yeah, that's for civic associations.
It's the same,
Same thing.
yeah.
Thank you.
So like what she was talking about, all right, people who won't cooperate with the rules and things. That's what you're talking about, right?
Well, it could be a homeowner.
Yeah, it's a
Okay.
homeowner.
All right.
Okay.
That there may not be rules in that community, like you
But-
said. But if you're talking to your civic association, or you're talking to officers, or they're doing their best and they don't know what to do with it, how do you communicate with that homeowner in order to live peacefully in your community? So he's saying start with that form, and then we go forward. Am I understanding that correctly?
Yes.
Okay.
The
Because you know we have license and inspection in the city.
That doesn't work out.
And so, in other words,
Unfortunately.
once you've gone through license and inspection,
Yeah.
you still can't find,
Any solution.
find a solution, then you can put in the complaint.
Right.
licensing and inspections has its own rules and regulations. They will, a lot of complaints with homeowner associations do involve licensing and inspection. And when that happens, they will send out inspectors who can write tickets and they can enforce them. And if they do, then if they get no response from the homeowner that's been ticketed, they'll pay for the recommend. Sometimes it's cutting grass that's way too long, or cleaning up messes that are unsanitary, and they will bill the homeowner. And the homeowner has to pay it, or they're going to get further fines and further enforcement by the county. We don't have that authority, but it can sometimes it can be diverted by using this process of the internal dispute resolution complaint form to try to bring the attention to the people who are causing the problem. And if they won't voluntarily and consensually meet to discuss the issue, then you have to go mandatory, and licensing and inspection is mandatory. They will take it and take care of a lot of problems through their own processes.
Attorney General, I'm glad she brought this up, because right now the situation is that license and inspection will very aggressively use the fact that a homeowner has mental illness or has quote unquote issues as a reason to do nothing. And the property takes on junk, debris, crime, animals. It spreads out and harms others. And they don't do anything year after year. So are you saying this internal dispute complaint form is a power above license and inspection?
No, it's below licenses and
That's what I was
inspection.
afraid of.
It's consensual and voluntary, as is the Court of Common Pleas Community Mediation Program, and our mediation programs are consensual. However, if they won't cooperate consensually and voluntarily, going to Chancery Court is mandatory.
Yeah,
Once
but
suit
for
is
people
filed,
to
there
go-
are court orders involved.
But sir, for people to go to Chancery Court,
I understand
it's
that,
out
that-
of reach.
I
You know, the
understand that-
lawyers, attorneys, one after the other, reject the cases. Don't even waste your time.
I understand that. Actually, that's a problem I'm looking into. I've been, I hear from many complainants that private attorneys are not willing to take the cases. And I read about them in the, such cases in the reports of the Chancery Court. And usually what I find is that the private attorneys are not taking cases because the complainant is incorrect on the law. But I also understand that there are situations where they are correct and it's just too expensive. So I'm part of my analysis is that I'm going to be reaching out to attorneys to try to get on to the get them to agree to at least speak to people about their cases and take more of them. I want to get more attorneys involved on the Delaware State Bar Association's online lawyer referral service so that they can speak to people for a $35 donation to the Bar Association. And right now there's only a couple of attorneys and they're pretty much overwhelmed by the volume. But I'm concerned about this issue, and I'm working on it by first studying the cases that people are saying they can't get an attorney, studying the opinions from many cases where attorneys do get involved, they do win, they do get attorneys' fees, and but they're few and far between. And then there are others that I think could become involved and with something less than a full-blown Chancery Court Section 348 proceeding could probably get things resolved if they would be willing to speak with people about it. I'm concerned about this, and I'm working on it.
I think there should be 2 tiers for Chancery.
I'm sorry?
2 tiers at least for Chancery because, you know, the big rich people, Elon Musk and the rest of them, you know, they pay these huge fees to come in and use this court, international court even. But the local people of the city, they can't, financially cannot use the court.
I agree that it's expensive. You should be aware that there is a sort of two-tier process in the Chancery Court. Under this Section 348, the first thing the Chancery Court does is appoint not a chancellor or vice chancellor. They appoint a magistrate in Chancery, and they have been putting more and more magistrates in Chancery on for first round of these community association matters.
That's good.
I was part of a conversation with one of the Chancery magistrates and some others 2 years ago, I think, when this came up. There was a question about whether Chancery Court would be willing to cede some of its jurisdiction and authority to Justice of the Peace courts for things like records requests and some other things that could result in Chancery Court or Justice of the Peace Court trials. But they are very Chancery Court's very protective of its jurisdiction, and I'm afraid that's still a work in progress.
Thank you.
I have one other question.
Thank you. Many of the codes are for rentals, where homeowners, there's not many codes that you can actually cite for violation unless it is through LNI. But what you hear from LNI or our police department, unfortunately, they own their home and it's not much we can do about it. What advice can you help us with that?
If they're renting out their homes, they're subject to the
This is a homeowner living in the home. That's where there's very little rules for homeowners in a community. When you look in LNI or you look at any website, it's usually for a renter. But this is a homeowner that you're using.
But there is a code that mental illness cannot be used as an excuse for property crime. That code exists.
So what I just said to Helen, what I would ask of you too, Ms. Moore, is send me an email with the specifics, with the address and the specific complaint, because this way we can direct it to the mayor's office, so we'll send it to the right department. But to discuss it in generalities is tough, because you are correct. Sometimes there are certain sections of the code that are only relevant to renters and not to homeowners. But just in terms of like general upkeep, and the laws in general are still relevant to homeowners. So.
It's just the way it's read, and I'm not the only
Yeah.
one. So I open up a can of worms. Just about everyone
Yeah.
here is like, okay, what do we do?
So yeah, it'd be good to dig deeper, and the more specific, in writing is good, because then we can forward it along in your words. So.
But that was just a general question about rules for homeowners.
Sure.
Period. Not that situation, but, when there's things going on in your community, people buy homes, they have no idea what the city rules are. Okay, it's not given to you when you sign your deed or when you're buying a home. And so that's where some of the lack of communication come in. You have a good community. We used to have a community where we had no police action. All the police would say, this is the best community in Wilmington. Now you hear about 15 times a month because someone bought a home and doing everything. And we're all saying, what in the world? Where did that come from? And how do we help to take care of it if we can't communicate with them?
We stay diligent. That's how we do it. Stay diligent.
Okay.
I'm sorry, I didn't understand your question, but I think Councilman did. And the general laws do apply to homeowners. Like L&I might be a solution for a problem that a homeowner has that looks like it's if a section of the code is aimed at only renters. Does that get to what you were looking at?
You would think that would be the case. I've had them to say, well, it's DELDOT or land use that has to come in and cite. You're like, what? And I'm used to dealing with L&I, so, we'll just start from the beginning. We'll send you loads of forms.
Well, certainly use them to try to cajole the person that's causing problems into a good position. Our processes, both mine or the Ombudsman's office and the Court of Common Pleas, are voluntary and consensual. And if they won't cooperate with that, and it's a problem for L&I is on a different, more powerful plane. And I'm not sure. I think the city probably has code compliance also, so make sure you're contacting the right jurisdiction as well. I mentioned the information about the IDR complaint. I had the next slide that I have is about information for voluntary civic associations. And I already mentioned the CCOBH, Council of Civic Associations website, but the City of Wilmington website for government services like code compliance, laws about trees, parking, sidewalks, responsibilities in government agencies can be a useful tool for civic associations as well. CCOBH has member communities in the city, so it's worth the time to look and see if they have some questions and answers that might address some issues that you're not finding answers to elsewhere, like in my office or the Court of Common Pleas Community Mediation Program. The Newcastle County website can provide a downloadable copy of the Civic Association Manual that they published decades ago, but it's still got good information in it and has some common problems communities face listed in them or in the manual and how to address them and where. And then there's, here's the citation I couldn't remember. The last one on my information for voluntary civic associations does discuss the Delaware Uniform Unincorporated Nonprofit Association Act. It is available on the Delaware Code online. That's a website of the most current copy of the Delaware Code. It's Title VI, Chapter 19. It doesn't have a lot of meat on it like the DeKiowa does, but it allows unincorporated associations to act as an entity for some valuable actions like entering contracts in the association's name and to sue and be sued in the organization's name instead of individual ownership names. Now, if you like, I can go into some other details about other things that are available through my office. Otherwise, I'm happy to answer any other questions that you have. I've got 5 minutes to yak. If you don't ask a question, I'm going to yak some more for 5 minutes. One of the things I want to yak about is that my office created some useful things, I guess not so much for community associations unless they have the ability to assess mandatory assessments for maintenance of things like roads or snow removal. We have a compendium of forms and information about using Justice of the Peace Court to file suits for a variety of reasons where there's a delinquency of one sort or another. Other issues and investigations that we have found recently that might be of concern is that we have civic associations bylaws may require elections, and we have seen many instances where boards of governing each community type has gone for decades without conducting any elections. and this may invalidate all the actions a board takes under Chancery Court interpretations of the laws for bylaws and notice and elections for corporations if they're incorporated. There have been instances of both common interest communities and community associations where bylaws were never recorded. And that's one reason I suggest, actually for common interest communities, I ask every community when I'm dealing with a complaint to provide me with a clocked copy of their bylaws, because that's required by law. If you've got a corporation and the bylaws have never been recorded, you can still insist that they be recorded as a best practice so that everybody can have access to them. There have been a number of corporations that I've dealt with where the developer created bylaws and provided them to every member of the community when the community first opened. And by the time they were complaining to my office, nobody could find them anymore. So I've started asking people who, with a complaint like that, if they have a mortgage or a loan, and if they would check those papers to see if they have copies of the bylaws or any other governing documents, like even a copy of their deed. Deeds might have deed restrictions that require some kind of participation, and with that kind of information in the governing deeds, we might be able to cajole mediation or arbitration.
Sir, is there a fee for following your bylaws?
No, in Newcastle County only, Mike Kozakowski, the recorder of deeds, has had statute law created for all of Delaware, but only Newcastle County has acted on it, that allows community associations of all types to record documents in the recorder of deeds office without charge. I'm trying to, I took Mike on the road to the other two counties to talk about the projects that we worked on together to see if they could be extended to other counties. But so far, only Newcastle County has done the three that I mentioned, including governing documents recorded without charge and governing documents searchable for free and downloadable for free. And that looks like my hour and a half. I'm happy to stay if anybody has more questions or would like to talk individually.
Thank you, sir. Thank you.
Thank you.
Thank you for coming out on a dreary Monday night.